so we can get started. Assalamu alaikum all, and welcome to another special segment of the Sanato Tijarat talks. Today we have with us Dr. Shakil Ahmed. So Jazakallah for your time in what you'll be discussing today. So just to give a bit of background, Dr. Shakil Ahmed is a chartered patent attorney. He's a European patent attorney and a chartered engineer with a strong background in electronic engineering and software technologies. He's a partner at Kelty LLP and he leads the IT, telecoms, and electronics team, advising on complex patent matters. He specializes in software, fintech, and emerging technologies with expertise in data security, app development, and patent strategy. Dr. Shakil has worked on major UK and European cases and is recognized as a leading IP practitioner. And he also delivers lectures on protecting software innovations. And today's topic, the talk will be Introduction to Intellectual Property. So, Dr. Shakil, I'll hand over to you. And I think, given that you've delivered lectures, I think this should be a walk in the park for you.
Thank you very much, Sam. I appreciate that. Assalamu alaikum, everybody. Um, Basically, today is going to be an introduction to intellectual property. I'll explain really what it is, what are its commercial benefits, and what you really need to do to secure protection. And just a little bit of background about me. My background, as has been explained, is mainly electronics, telecommunications, software, but I went from engineering into the legal profession about 35 years ago. So I've been doing this for a while now. And whilst my area of specialism is patents, certainly high-tech patents, I do cover all kinds of intellectual property, and that's really kind of what we're going to talk about today. So, and another little thing that's quite useful to kind of get things into perspective is that the legal profession in this country has probably got something like 200,000 solicitors. The number of patent attorneys is probably something like just 2,500. So it's very, very niche, small area. And a difficult profession to get into, but thankfully I'm not having to get into those professions now. I did that 35 years ago. So let's move on to give you some idea about what this is about. Okay, so the first thing we're going to talk about is what is this thing called intellectual property? It's often abbreviated as IP, but that's not to be confused with the Internet IP address acronym that's used. So intellectual property in its basic form is really it's legal protection for creations of the mind, things that you come up with in your head that you wish to then try to protect for commercial exploitation in whatever field. And there are lots of different types of intellectual property. Now, each one, and I'll go through these examples in a second, but each one of these comes into being once you have recorded them on some kind of tangible form. That maybe you write it down or you record it with an electronic means or whatever, but you must have kind of put it into some tangible form for it to be created. Um, so some examples here, for example, are brand names and logos. Those are probably the ones you come across most in your life. The example here, Lego, has got two things. So the letters LEGO, Lego, is the trademark, and the logo is the way in which the graphical representation of that mark is presented. And you'll see that in all walks of life. But that kind of branding for your products or your services is a type of IP that can be protected. The area where I work most is inventions. So inventions can be in fields from chemical, mechanical, electronic, software, all these different areas. Materials can be covered by inventions, and they can be protected as a type of intellectual property. And I'll talk about that in a little bit more detail later on. Um, Another form of IP is creative works. So here we're talking about things that um, an artist has created, or someone, if you've written a book, or you've written a song, or you've painted a picture, those things are also protected as they are because they are a type of intellectual property. Um, Similarly, with designs. So to give you an example, company here we've got an example of an Apple logo. So that could be a trademark, but it can also be a design. The way in which it looks and the way it's presented can be protected through design protection. An example of that, which is really quite familiar to you, will be a company like Dyson. So if you see a vacuum cleaner from Dyson and you compare that to another vacuum cleaner, you probably recognize the Dyson one or see that it's Dyson because of its design. It's very kind of like unique design that's quite well known. Um, and the other type of intellectual property is in confidential information. So we're talking about trade secrets, secret formulas. The good example of this is the formula for Coca-Cola, which rather than filing a patent for it, which they could have done, they believed that they would keep it secret and nobody would be able to reverse engineer it. And for 70 years, that was exactly the case. And the formula of Coca-Cola was never reverse engineered. So these are examples of what intellectual property is. The ones that really apply to business most are confidential information, inventions, and brand names and logos. Those are the real ones that are the main focus, and we're going to talk more about those now. So um, these types of creations can be protected by two types of intellectual property. The first type is called unregistered rights, and the second is called registered rights. So what's the difference? Well, unregistered rights, you'll be glad to hear, they're automatic and they're free. You don't have to pay anything for them. They come into being once you do this recordal into a tangible state. So with copyright, it comes automatically into being as soon as you write a book or you write an essay or you know, paint a picture, it automatically has copyright. And what you can do is you can put the symbol C in a circle next to anything. So for example, if you've got a website and you've got the wording you've written in the website, you can always put at the bottom that you know the contents of this website are copyright protected with a C in a circle, and often a date when that copyright was. A similar thing applies to design right. So the shape of configuration of a 3D or 2D industrial article can be protected automatically. And that often protects things which don't necessarily have an aesthetic creative kind of component to them, but they are much more functional. So for example, like a spanner may well have design right in it because it's a very functional thing. It's not really very artistic or anything, but it's a functional thing that can be protected. Um, I've mentioned trade secrets, that's confidential information. It's important to keep those well documented in order to have those trade secrets. And of course, they're only as strong as you keeping them confidential. Um, Trademarks and service marks. Well, these are things which are covering your brand. In order to get protection, you really have to build up a reputation. So people, when they see your mark or your name that you're using, uh, it has to be something that they recognize with you specifically, not other people. And then you automatically get rights under unfair competition. All of these unregistered rights are fine, but they have weaknesses. So, for example, with copyright, you have to prove copying. If somebody came up with the same creation but without copying you, then they don't infringe your copyright. Similarly, with design right, it requires you to have actually physically copied what you saw. With trade secrets, the weakness is the fact that as soon as the information is disclosed to the public, even if you didn't do it yourself, if somebody in your company leaves and discloses something, then the trade secret is no longer a trade secret. Or someone could maybe able to reverse engineer what you're doing. Finally, the trademarks and service marks, like I said, they are to do with the common law rights that you've obtained by use of this mark. So you must have built up a reputation in order to use these unregistered free rights, if you like. The alternative to these is to use registered rights, and of course they come at a cost. Um, so the most powerful IP right that's available are patents, and what they do is they protect a concept that if you like, a technical concept that you've come up with that will as I said, it can be any field, but it's something that you are going to commercially exploit, or you wish to give to other people to commercially exploit. You can protect that idea in a patent, and they are for 20 years in duration. And we'll talk a little bit more about that in a few minutes. You can register a trademark. Now, the advantage of a registered trademark over something that's unregistered is that you don't have to prove any kind of reputation. It's the first one to file the trademark gets the rights, and it's done on a country by country basis. And we'll talk a little bit more about that in the next slide. But they protect, a sign, a symbol, word, logo. And these are things that get a consumer to associate that product or that service with you as a badge of origin. And finally, registered designs. Now, these are designs where there is some aesthetic quality to what you've created. So, to give you an example of the spanner that I talked about earlier, if you've got a very particular color scheme that you use to it, that could be the subject of a registered design. Not the functionality, but the, if you like, the expression of the idea. How have you expressed it? But registered designs can also be filed for 2D objects. For example, a website. If you've created a very special website that has got a real nice look and feel to it, the way you've created it, that can be protected by a registered design. It's the shape and the configuration of that object or design. And then the law is that when you've got that protected, it can apply to any object. So if I've got, let's say, a particular picture of, going back to my spanner example, with its great color scheme, if that's applied to a t-shirt, that's protected by a registered design. If it's applied to a website, it's protected by the same registered design. It doesn't matter which product you apply it to, it's the design that's protected. So these are how they are done. So with a trademark, you will have R in a circle next to the symbol or word. That tells you that it's registered. Whereas if it's unregistered, you can use TM or SM for service mark as soon as you start using a trademark, even if it's not registered. So that's the marking of it. And with a registered design, you'll often see the number which it relates to. So let's talk a little bit more about trademarks, because this is what you'll have come across most in your commercial life. A trademark, as I said earlier, the big advantage of a registered trademark is that you do not have to prove you have any reputation in that mark. Once you file a trademark, you've got 5 years to really use it, to start using it. And the registration is done in such a way that there are 42 goods and services classes, and your mark has to say which goods and services it applies to. So for example, if you've got back to my spanner example, if you've got a particular mark for that, let's say you called it pilot for spanners, the word pilot would be registered under the goods under the classes which relate to those industrial goods. So it might be mechanical tools or whatever, and that's what your mark would apply for. So if anybody else used that same mark for the same goods, then you could stop them by using your registration. Now, there are services as well. So if you're providing education services or you're providing training services, those are special classes that you can apply your mark to. And if anybody uses the same mark in those classes, then that's what your registration protects you for. It does not protect you for the same mark in a different class. But you can choose as many classes as you think are appropriate, and you just have to use it in those classes within 5 years. So when we file a trademark, we pick those classes, but we also set out words within the class which describe what you want to protect. That's called the specification. Trademarks last literally forever. You just keep renewing them every 10 years. They're not hugely expensive. And so it's good practice to do that, to add value to your company with the intellectual property. They're covered on a country by country basis. So interestingly, for trademarks, you can file a trademark in the country that you're active in. And when you develop other markets, you can subsequently file trademarks in those markets as well. You don't have to do it all in one go. The European Union is covered by a single trademark. And remember, the UK is not part of the European Union, so that has to be covered separately. Um, so you've worked out what your mark is, and you've applied it to you've worked out what your specification is. What do you need to do to get your trademark granted? Well, there are certain tests that are applied. The first one is that it has to be distinctive. Can it distinguish your goods from other people's goods by virtue of the mark that you're using? So what does that mean? Well, there are certain things that it has to be non-descriptive. In other words, you can't describe the goods which you're going to apply it to. So for example, I've given some examples here. Pakistani mangoes, you cannot protect that because Pakistani tells you where the mangoes are from. And if you think about it, every street seller who sells mangoes will want to say these are Pakistani mangoes because, of course, they're the best in the world. So the idea is that you do not use words that describe the origin of where those goods came from. Similarly, you can't describe something that's laudable, something that people would want to say about their services or their goods. So fast delivery, for example, for courier services would not work either because everybody in that industry would want to say we've got the fastest delivery. You can't stop them using that word because it's a common word that they want to use to describe those services. However, an example of something that does work is elephant atta. Elephant doesn't tell you anything about where it came from, doesn't tell you anything about the quality of the goods or what they're about, but it gives a hint to the fact that this might be from a place which has elephants. So it's a good trademark in that respect. It gives a suggestion of what you want it to say. So if you put elephant atta, you wouldn't think that that comes from America. It doesn't sound right. So that's what you need to do. You need to have it needs to be distinctive because it's non-descriptive. Similarly, it has to be original as well. It has to be something which is not already registered for those same goods and services. So if somebody has filed already for elephant atta before they filed, they would not be able to get that trademark registered. In fact, they would probably be stopped from using it. And another thing is that your trademarks can't be misleading. You can't say something which is not true. So, for example, if you have the example I've given here is if you use the word pure Swiss for chocolates and the chocolates are not from Switzerland, that's misleading. So people will assume that they are from Switzerland. So you can't do something which misleads people. That won't be allowed either. But assuming you can pass those tests, you can get a registration for your trademark within 4 to 6 months of filing it. The flip side of this is that let's say you haven't filed a registration, you're not interested in that, you just want to use your mark. If you apply your mark to your goods and services and you start putting them on the market, you may well be stopped from doing that because somebody else may have that trademark. So the idea is for those goods or services, the idea is before you launch a product, my advice to you would be to do a search before you launch of does anyone have this trademark in this country for these goods and services that I'm applying for. Now, patent and trademark attorneys can do that for you, but you could do something yourself as well to find out what's out there. The trademark registry has a search tool on it which you can use to do that searching yourself. Where it becomes a little bit difficult is where marks are similar but not exactly the same, and then I would tell you to go and get some advice. Okay, so having talked about trademarks, let's talk a little bit about patents. This is the thing that I deal with most in my day job. I suppose it's the most complex and the most powerful IP right there is out there. So I suppose the question is, what is a patent? Now, governments don't like monopolies. They try to avoid monopolies at the best of times, but they tolerate patents. And the reason why they tolerate patents is because effectively they get their pound of flesh from you. What they want from you is you to describe your invention in great detail in a patent specification and then apply for a patent. And within 18 months, it will be disclosed for the public to see, the whole world to see, in fact. So what they're getting from you is disclosure. And if at any time you drop out of the process of patenting for whatever reason, they have effectively taken your technology and put it in the public domain for people to see. So the degree of disclosure doesn't have to be down to the most sophisticated, technical drawings of what's going on. It's a disclosure of the idea. So, for example, in software, we're not talking about code, we're talking about a functional specification of what's going on, if that's a patent, or what you're trying to patent. So we have this 18-month publication period where whatever is disclosed in your patent or written in your patent specification will be published. Before that, after you filed a patent application, if for some reason you change your mind, we can pull the application to prevent it from being published. So that's possible as well. Now, patents have a 20-year term, so you'll get the benefit of patent protection for that period of time. After the 20 years, then it's free for anyone else to use. But usually, commercialization within a 20-year term is usually fine. How long does it take to get a patent? Well, typically 3 to 4 years, but we can accelerate that. Um, the reason why is because it goes through different stages, and also because you have to file a patent quite early on in your development of an idea, certainly before you disclose it to the outside world. And I'll get onto that in a second. Patents are territorial, they are country by country. So you have to think about your markets where you're interested in. But fortunately, you don't have to file in every country immediately. You can file in, let's say, the UK first, and you've got a year to file in other countries. You can extend that to 1.5 years by using the international filing system. But essentially, that's the period of time you have to make your decisions as to which countries you want to file in for your commercial benefits. It is the most expensive IP right because it lasts for so long and it's so powerful. So it's not a right to be really used or sought after unless you really have got some commercial objectives or commercialization of the idea, which is then going to help you pay for this. So let's move on to the next slide, which is why? Why should we have a patent? I'm running my business fine. I don't need a patent. Why do people file patents? Well, really, it has to be, as I said, a commercial decision. It has to be something that you're prepared to pay for and you're prepared to see what commercial benefit it will give you. Now, you would think the most common reason for filing a patent application was to give you protection for your idea, but that's not the main reason why most corporations or companies file for patents. The number one reason of that list of reasons is adding assets to their company. And that's really highlighted by that graph at the bottom of this slide. If you go back over the last 50 years and you look at things called tangible assets and intangible assets, many of the accountants may know this, but tangible assets are things like machinery, factories, equipment, even people, to be honest with you. These are the assets of a company that were tangible, that are tangible. And back in 1975, 83% of a company's value was by its tangible assets, and only 17% by its intangible assets. Intangible assets being intellectual property, know-how. These are the main two things that are intangible assets. Possibly reputation as well in the marketplace. That's also intangible. And as you can see over the years, the value of companies, and this is from the S&P 500 in the US, has dwarfed all of the tangible assets. So 92% of the assets of a corporation, of these S&P 500 market value companies, is in intangible assets. So it's become a very, very important part of the value of a company. And that's why people file patents, because they want to add assets to the company. It does provide a deterrent effect. If you go around telling people that you have a patent, they will think twice about possibly copying you. Maybe they will think, okay, this maybe leads to a licensing opportunity. Well, we'll take a license under your patent so you can generate a revenue stream in that way. There are a couple of companies out there that use patents for marketing as well, because what they do is they say, we are a high-tech company. And as a high-tech company, we file patents because that's a badge of showing you how innovative we are. So companies like Dyson, L'Oreal, they will file a lot of patents because they want to show the world that they are very innovative, and they use that for marketing as well. the final thing on that slide there is about tax benefits. So um, if you have a UK granted patent or a European patent which designates the UK, you can pay, instead of paying 25% corporation tax, you can use something called patent box and you can reduce your corporation tax to 10%. That's also that was introduced about 12 years ago in the UK. And it's one of the major reasons why the financial industry files patents, because not because they're interested in any of the other interesting points, they're interested in reducing their tax. And so I file patents for hedge funds, for spread betting companies, for insurance companies, for banks, so that they can utilize reducing taxation of their profits down to 10%. So let's now look at what you need to do to get a patent. So there are three steps, there are three hurdles that you need to overcome to be granted a patent. Um, so you've prepared your patent specification, you've filed it at the patent office. They will do a search first to see what else is out there prior to the date of your filing. And when they get the results of that search back, they will show you the results and they'll say, they will do their tests. They will say, okay, we've got these documents, now let's apply our tests. The first one is novelty. And what that means is that they will ask the question, is this idea already in the public domain somewhere? So for example, if I was to file a patent for a wheel, the first thing that they will do is they will do their search and they say, well, we know about wheels because everybody knows about wheels, and therefore that lacks novelty. Now, it's important to remember when you have a new idea, particularly if you're linked to a university, universities are very keen to publish their ideas so they get the first person to publish this idea gets all the credit. That's completely the opposite to patents. You must file a patent application before you do any publication yourself. Don't go around telling people about your idea. The more people you tell, the less chance there is of it being novel. And certainly don't make a presentation which discloses how your invention works to anybody else. It is okay to do, if you like, a black box kind of disclosure, saying we have this invention, it can do X, Y, and Z, but we're not telling you how it does it. That's a non-enabling disclosure that won't count against you, but you must be really careful about what you disclose. The best practice to do is to not to disclose anything until you've spoken to a patent attorney and filed a patent application. That's the best practice. You can also, before you get involved with patents, do your own searching. There are some free online tools that allow you to search for existing patents. And I'd highly recommend to do that before you start spending money on patent attorneys like myself. No, so assuming you've got novelty, someone's not done this idea before, that's great. You've passed the first test. The second test is inventive step. Is this idea obvious? So it's a very subjective kind of idea. How clever is your idea? It depends on who you ask. If you ask a university professor, they may think that something's very obvious, very, obvious to do because their level of thinking is much higher. If you ask a university graduate, they might think that's quite clever. So the inventive step question is quite subjective. The way that the patent offices deal with this is that they look for an advantage associated with the difference in what you're doing and what's been done before. So, for example, if I was to invent a table with 1,000 legs, the patent office would say, well, we've never seen a table with 1,000 legs, so you passed step one, novelty. But surely you fail on inventive step because all you've done is add extra legs. And we know tables with 3 legs, 5 legs, 10 legs. So that would not pass the inventive step test. It has to be an advantage associated with the difference. And the last category is there are a list of non-technical things which cannot be patented in Europe and the UK. They might be able to be protected in other countries, but in the UK and Europe, it's not possible. And they are things which are considered to be non-technical, such as a method of playing a game, a method of doing business, an accountancy, rule, scheme, presentation of information. These things are considered to be non-technical. So what we are looking for in order to overcome this step is that your invention has solved a technical problem, not a commercial problem. So we're looking at within the technology, what has your idea solved? And if it has solved something, then it's technical. So some examples of that, even within software, for example, cryptography is like a more secure key, lock and key. That's fine. Image processing, because you take an image, you may process it in software, and you get a better image out. That's considered to be technical, a technical problem there. So these are the kinds of things that you need to look at for getting around this particular step. So that, in a nutshell, that's what we're talking about. These are technical inventions that protect you for what you've got. If we look at the next slide, this gives you kind of a summary of what we're talking about. So we have patents, trademarks, registered designs, and copyright. And the first row tells you what they protect: inventions, brand identity, words, logos, what the product looks like, its look and its appearance, if you like, as well as copyright, which is the actual expression of that particular idea in copyright. How long? They all have different lifespans. As I said, patents 20 years, trademarks can be renewed forever after 10 years. Registered rights are, you get them for 5 years and then they're renewed in 5-year chunks up to 25 years. And copyright exists for life of the author plus 70 years, but sound broadcasts are only life of the author plus 50. So they last for a long time, but as I said, they're very limited right copyright. And the slide also shows you what it gives you protection for, your idea. And remember, in a patent as well, there are two parts to a patent. One is the claims, the language, which is the legal documents, legal paragraphs which protect the actual concept that you're trying to protect. And the other part is a specific description which explains how to implement the one way of implementing that particular idea. You're not restricted to that one way of implementing it, and you don't even have to have actually implemented it. But if you can describe how you would implement it, that's sufficient for what we need to do. So that's kind of like an overview of what intellectual property is. I've kind of rushed through that because I want to give enough time for questions if there are any, but I'm happy to kind of go over anything else at all. So I think I'm okay for time.
Yes, no,
Okay.
you've done really well with time. Jazakallah. I think just before we do move on to any questions, I'll just say from my side, so a very interesting area. Definitely not one that I think people think about when they are managing a business or looking at a product. I think it's something that's overseen quite a lot, actually. So, Jazakallah, I think thank you very much for bringing this to our attention because it can be an area that's quite complex. And just like knowing that we have someone in the Jamaat who is, an expert in this, it's really helpful. So we do have some questions that have come in the chat. Whilst I go through these, if anyone else has any other questions, please feel free to continue putting them in the chat, and we can see how long we can hold on to Dr. Shakil's time for. So the first question is we have a member has mentioned that he makes bespoke wooden furniture pieces, and each piece is unique, but it can be easily copied. How can he protect his designs?
Well, I think the ideal way to protect it is using a registered design. Now, they can be relatively inexpensive, and you have, for example, if he's making furniture, which is, for example, a chair, a table, um, or maybe a sofa, you often get pieces of furniture which have a similar a theme running through them because you can tell they're part of a set. You can protect each one of those items of furniture in a single registered design application. Um, and it gives you the ability to get individual protection for all of those things. If someone's copying that design, then the registered design will be able to be used against them. And as I said, you can get a single registration for the European Union. You can get a single one for the UK as well, which covers multiple designs, so long as they relate to the same kind of article. Sorry, same type of article rather than the actual article itself. So if it's furniture, you might be able to file several designs in one application, and the cost is not as expensive as filing individual designs to each application. And it's very quick as well. So you would probably be able to, if you filed a registered design with the right black and white line drawings of your furniture, you could probably get registration within about a couple of months, which would be an enforceable right. You can put registered design numbers on all of your websites and all your literature, and in fact, even on the articles of furniture, which would give you the rights to that protection.
Zagla, just for my own interest, it might help the person here as well. How would he go about proving someone might have copied his design? Will that be quite difficult?
So the good thing is for registered designs, you do not have to prove copying.
Right.
What the judge would do is he would take a picture of the design that you've registered or the design registration, and he would take a picture of what is out there on the market that's apparently infringing. And he would make us, do they look similar enough to me? Yeah, they do.
Right,
You're infringing.
right.
So it's the features that they have in common that are the key thing. But you don't have to prove if the person came up with a design independently of you, if you have a registration for it, it doesn't matter. The only way which copying is an issue is if you're relying on unregistered design rights. Unregistered means you have to prove that they actually copied it. But if they didn't, if you can't prove it, it doesn't matter. If they look the same impression, then that's enough to show infringement.
As long as you registered it first.
Yes, yes, exactly.
Okay.
And there have been cases where I've done that for clients that they have a registered design. They've seen a Chinese copy that's come and is flooding the market, and I've sent letters to the infringement saying, "Here's our registration. Here's your design side by side. If you look at them, they're exactly the same, or they're very similar, similar enough to cause confusion to for our registered design, and therefore you have to stop what you're doing." And the vast majority of importers of these kind of goods, for example, just say, "I'm very sorry," and they stop selling it because they don't like to get a letter from a legal firm,
Yeah,
basically.
I can imagine. The next one is a bit of a complex question. I don't know how long this one will take. We do have a few, so I'll see how quick you can get through this one. So, what are some examples of data privacy requirements, and how would you go about building out an AI ethics framework?
Data privacy, it's a very broad subject. I mean, it can cover all kinds of things. It can cover encryption, it can cover security for what you do. So I'm not sure about that, but AI, I can tell you a little bit about. Um, because we can get protection for AI inventions, but the AI itself has to be doing something which is tangible. So if you got, let's say, an image and you apply some AI to it to convert the image into a better image without red eye, change the lighting, etc., you can argue that the AI has been trained on various good images, and it also knows what a bad image is with shadows and red eye and all kinds of artifacts that you don't want in the picture, and that it corrects it. So what you get out is the AI is actually controlling a process to generate a new image, and that's fine. So you can use AI in that. You can use AI to control a process, control even if it's opening a door or not, face recognition in a much more accurate way. That's fine. In terms of data privacy, I think it's a very broad concept, but you can protect encryption, you can protect um, firewall security. Um, you can protect data formats if they give you a more secure way of doing things. All of those are possible. So I don't know if that kind of helps.
Yo, Jeff, please let me know in the chat if that does answer, or if you've got any, if you can elaborate more, then that'd be great. But I'll move on to the next one, hopefully more of a simpler one. So this member has asked about the Easy Group, so EasyJet, etc. So how did Easy Group manage to trademark the word easy? Um,
Well, yeah. So if you go to the slide where I described, is it descriptive? Is it
mhm.
laudatory? Easy doesn't necessarily mean it's well, it was difficult. They had some difficulties with that because it was on the borderline of what was allowable. Now, what you can do is if you file a trademark and you show that you've got several years of using the trademark and people associate the trademark just with you, that
Hmm.
can be enough to swing it in terms of those cases which are very close to the borderline to say, okay, with the evidence of use, we will allow you to register this trademark. Also, they registered the color that they used for EasyJet, for example, that bright orange. So use of the word easy with the bright orange is very much their protected logo and trademark. Um, they might have difficulty enforcing easy against people who are saying, oh, my process is an easy process,
Uh-huh.
because
Yeah.
someone would say, well, I'm just using it in normal parlance. So they do have it very specifically for EasyJet for aircraft and airline services. They have other easy hotel and easy other things as well. But they're very specific, and they've had to argue that only through use over several years have they built up a reputation, and that's enough to get them just over the line when it comes to registration.
Yeah. I think maybe the same might be applied for Uber, which is a German word, but I think no one would associate it with a German word unless you're German yourself. But you'd automatically be thinking of
Well, you wouldn't associate with ride sharing and taxi services. No, Uber doesn't necessarily tell you anything about it. Certainly in English, you don't.
no, of course not.
Therefore, it's the best words actually are the ones that are invented, like Kodak. Kodak
Mhm.
is a word that's completely manufactured, doesn't mean anything, but it's something which you can easily get registration for, and then you build up a reputation in it.
Jazakallah.
Hmm.
Another question was, where is the line between a program and a technical invention?
Right. So a program per se can't be protected. So that's one of the excluded lists. So let me
Mhm.
give you an example. Let's say I had a program that takes a number, multiplies it by 2, divides by 7, gives me the square root, and I get another number. I can't protect that algorithm or that computer program because it's just taking a number and doing something with a number. It's very abstract. As soon as I take that and I apply it to a process, let's say cryptography, where I take a message, I apply this algorithm to it, and I get a secure coded message, that's protectable. Or if I take that algorithm and I apply it to image processing, if I take an image, which is all zeros and ones, if you like, and I apply this algorithm to it, and I get a better image out, then it's protectable. So it's the application of that program that we're looking for, and ultimately, what we're looking for is, have you solved a technical problem? In the case of a picture, I'm saying my problem is that I have a picture with artifacts in it, or I have a picture that's not very good quality. Let's say it's low resolution. I apply this algorithm or this program, and I get a much better picture out. So my problem was that I had a poor image. And now the solution is I apply my algorithm, I get a better image out. So if you can find a technical problem that you have your invention is a solution to, it doesn't matter if it's a program. In fact, I spend 80 to 90% of my time protecting innovation, which is in software, which is all programs really, and now AI to a large degree.
Jazakallah. Um, this is a really interesting one as well. I think this would be good for people that are looking for investors in their businesses. Do investors, this one specifically says UK, but just in general, do investors actually care about patents for software businesses?
Um, I would say if you asked me that question like 15 years ago, I would have said not really. They don't really care that much. They're much more interested in, what the commercials are of the product, and the people behind it. But
Mm.
actually, now things have changed somewhat, in that they know how easy it is to reverse engineer software. You can just look at how something's been generated, and you can use, with generative AI, you can recreate software quite easily. So it is becoming more important for investors. What they typically do, they've got a list of things that they tick off, and IP is one of them. But the real game changer for investors is the fact that you can get a tax benefit for this. So the profits of your product will not be taxed at 25% corporation tax, they'll be taxed at 10%. And that's for 20 years. So the cumulative effect of the tax saving for a product that's going to go hopefully very big or very, be very large scale could be quite huge. So investors, I wouldn't say it's their number one priority, but they are interested in seeing if you have, and they do consider if you've got patent protection for a software invention to be a badge of excellence, if you like, in terms of, well, this is really innovative. Uh,
Hmm.
so, and as I said, it can also help um, customers of that product to think that, oh, great, I'm getting a product now that's patent protected. That means that other people, if they start competing with me, they'll be infringing the patent, and I can tell the patent owner, and he can take some action against them. The monopoly that the patent owner gets can be to the benefit of the customer as well, because the customer gets this protection, this umbrella protection in their marketplace. So they can be the only player in that marketplace because of the patent. And again, investors understand that.
That's interesting. So yeah, not just investors, but your customers only will probably look for that solution that does have that
Well,
patent.
they might be willing to pay you more if they have exclusivity, and the patent gives
Mhm.
you that exclusivity.
Of course, of course. No, Jazakallah, thank you. This one this is a similar to a question I had myself actually. So the question asks for a startup building a tech product, how important are patents early on? And maybe you can mix this with my one. Is at what point in the business or product life cycle should you know if you need to protect your brand, invention, logo, or whatever it may be?
Right. So in trademarks are different to patents because
Hmm.
trademarks are to do with the market when you're
Yeah,
launching a product. Okay, so that
right.
could be quite later on in the development process when you've got funding, you're about to launch. That's the
Hmm.
time when you need to think about trademarks, maybe do some searching yourself, make sure that you're not going to trip over somebody off or over somebody else's trademark if you launched. You might even at that stage think, oh, well, okay, maybe if I file a trademark myself, that would be a good thing to do. So that's probably later on in that process.
Hmm.
But for patents, it has to be quite early on.
Hmm.
And the key thing is disclosure. When you're developing something in-house, that's absolutely fine. When you're going to speak to someone about it, if you can get them to sign a confidentiality agreement, again, you are legally, you're fine. If you're talking to an investor, um, it's very difficult to get them to sign a confidentiality agreement. They're not really going to agree to that. So at that stage, you should be thinking about, well, maybe I need to go and get some advice on this to see what I can disclose, what I can't disclose. If you can disclose your invention in a kind of a black box kind of way, saying, I've got this great invention, great software, I put these inputs in, and these are the outputs I get out. Isn't that fantastic? You haven't actually disclosed how you do it. That's called a non-enabling disclosure. And that may be enough for you to get interest, get other people's money into your company, and then use the money to file a patent application. Rather than putting your own money into it, which is always a risk. But I think with patents, it has to be early on. And the key thing is disclosure. When are you going to you mustn't go and speak to produce a white paper on it and put it on your website to say how wonderful your product is, because that could actually, you could just be sacrificing all your IP rights by doing that. And usually the first meeting with a patent attorney is free of charge. So they'll give you an hour, half an hour of their time just to hear about what you're doing and give you advice. So you don't spend anything by just having a conversation.
Oh, perfect. That was one of my questions as well, saying this is a quite a complex field, and is there somewhere people can go for free advice or guidance? So, no, thank you very much for covering that.
Yeah.
The next question is, if you're considering a joint venture in a growing business with someone, is there intellectual property rights and protections that should be considered to protect and put value on the original business? IP in the form of processes, departments, links, and contacts with regulators. I'll give you an example.
Right. So it comes under kind of confidential information and know-how. That's all valuable. Again, so as I said, if you've recorded this in some form, some tangible form, it's very important to document it and keep it all really close. So when you go into that joint venture, you say, well, me as a person who wants to join this, or a company that wants to join this, do this joint venture, we have our own intellectual property, which is all documented, written down, and that is going to be our intellectual property, the originator's intellectual property. And if you want to use it, then we will give you a license to use it. Yeah. So it's very clear who owns it. if you're talking about patents or registrable rights, then they will have been filed in the name of the original entity. And again, they can be listed in an agreement which says this IP belongs to party A. It does not belong to the joint venture. It does not belong to party B. And so it's quite clear who owns what at the outset. Now, you may have a different set of conditions for things which are developed jointly. They may be something which is owned by the joint entity. That's fine. But what you go into that joint venture with, you need to ring fence it. You need to describe it, have it written down and listed in any agreement so that it's quite clear what's yours and what's the other party's before you join. And it has value as well.
So Jazakallah, I think that's what you mentioned about I guess this confidentiality agreement and documented things. I think this is specifically mentioned in the Quran as well that these things should be documented. And I
Yes.
guess this is something, something that was written a long time ago that Muslims would have been ahead of the curve in terms of knowing these things and documenting them. But no, Jazakallah, thank you very much for that. And another one I had was I know that some patents can take years to approve. So whilst a patent is being looked into, can someone then take the idea while it's still pending?
Okay. That's a very good question, actually. Um, you're right, patents can take a long time to approve. And actually, that's not such a bad thing. A lot of companies actually like that because it spreads out the costs as well. You don't have to pay all the costs in a very short time scale. What you're doing is you're getting your business up and running, you're generating, you may be even looking for investment. That takes time. So you don't want all the costs concentrated into the first year, for example. So spreading it out is quite good. Well, what happens is as soon as you file a patent application, you stop potentially you stop anybody else from filing a patent application to the same idea. So you stop the clock on that idea being something which is new for anybody else after you. Yeah. Um, but that, of course, as you rightly say, that doesn't stop someone using your idea if they find out about it before you've got a patent granted. Well, what the patent system says is that as soon as your patent is published, and it might take 18 months, but we can accelerate that in certain cases, but as soon as it's published, it starts a meter running for damages. So if I publish my patent and then a competitor of mine looks at my patent and says, that's a great idea, I'm going to start using it. They start using it. You can't stop them until you get a granted patent. But as soon as you get your granted patent, you can get an injunction against them to stop them doing what they're doing. And you can get them to pay you damages going back to the point when the information was disclosed in your publication. So you may not be able to get the remedy of stopping them doing what they're doing, but you can certainly get compensation for markets that you've lost, for their profits, for your lost profits. All of this is accountable, and you will say, stop what you're doing, but not only that, pay me for the damage that you've caused to my business by taking my idea. That's really what the
And Jazakallah, thank you for that. I think that's answered the question really well. I think look, that is all the questions we've had. Just maybe quickly, I know you mentioned in terms of advice, you said you can normally some firms allow you maybe half an hour free worth of
yeah.
chat. Is there any other advice in terms of
Right.
resources,
Yeah.
websites people can read up on that
Yeah,
you have?
so absolutely. Another very good question. So if you want to find out a bit more about trademarks, there's a lot on the internet. The website you need to go to is the UK IPO.
Okay.
It's an organization, the government organization, which actually grants patents, trademarks, designs. They've got examples on there. They've got a full explanation of all the different things I've talked about. But it's the UK IPO, United Kingdom Intellectual Property Office is what it stands for, but it's the UK IPO. If you type that into any search, you'll find it. And that will give you some basically information which supports what I've been saying. In addition to that, I mentioned that you might want to do searches for trademarks before you decide on a brand or patents to see if anyone has actually invented your idea before. And there are some free online resources that allow you to do that in a limited sense. So the UK IPO will have a trademark part of it, and that will show you how you can do searching for different trade names to see, a bit like in Companies House where you can search for a company name. It's a similar kind of thing,
Mhm.
but it will give you whether or not the trademark is in force. It will tell you what goods and services it covers, and it will tell you who owns it as well. So those are all the things you can find out for trademarks. For patents, once a patent application has been published, it goes into the public domain and it's searchable by websites, which one of the most common ones is called, you can use Google Patents, but one of the most common ones is called Espasnet, which is the European Patent Office database for all intellectual property all around the world. So you can usually find documents on there. And you can type in keywords or the name of a company and see what they've patented. It's quite easy to use, and that's quite a useful resource. And certainly, if people who come to see me who've got a great idea, I do often tell inventors, rather than spending money with me, why don't you go and do some own searching yourself? Give yourself some comfort as to whether or not this has been done before, and then come back to me, and then we'll take it further from there. So yeah, there are lots of online resources available. UK Patent Office, UK Intellectual Property Office, and the European Patent Office have got a lot of the resources.
Brilliant. Jazakallah. Look, thank you very much for your time. I think we are coming to the end of the talk. I appreciate your time in giving us this information. I think it's been very valuable. I hope whoever has attended has gained a lot of benefit from this. I believe your contact details are here, which I'm sure if someone is to have any questions, I'm sure you'd be happy to provide
Yes,
any support.
absolutely.
Given
Happy
some
to have a chat with somebody about
and
any of
you've
these
given
things.
some guidance in terms of where people can go. So Jazakallah all, thank you very much for attending. And once again, Jazakallah to the Sanato Tijarat team to organize this talk and for Dr. Shakil Ahmed Saab for giving us his time today. We will see you again next week, inshallah.
Yeah, thank you very much, Shoaib. So appreciate it.
Jazakallah.
Jazakallah. Hafiz.